Good evening, everyone. Welcome again to another live streaming of Basic Transfer Pricing. I would like to say thank you po sa ating mga subscribers. Ilan na? Ilan na tayo, Hari? Yung ating subscribers sa Basic Transfer Pricing. Okay, so thank you very much sa ating mga subscribers. Umabot na po tayo ng 790 subscribers for the Basic Transfer Pricing. No? Our topic for tonight is when to use the comparable uncontrolled price or the CAP method, and also the discounted cash flow method of valuing intangible. We will also discuss the case of Principal Commissioner of Income Tax versus the Redington India Limited. No? This is a case decided in 2020, pero appeal pa lang po siya, no? So, hindi pa natin masabi kung the parties will bring the case to the Supreme Court, no? So, hindi pa siya nakarating sa Supreme Court. This is just an appeal case. No? Shout out. Ilan yung ating viewers? Okay. Okay. Sige. Okay, so let's continue with our discussion on when to use the comparable uncontrolled price method. Bakit kailangan nating i-apply yung comparable uncontrolled price method? Because when we make transfer pricing analysis, balik po tayo sa purpose ng transfer pricing, no? When we say transfer pricing, we apply the arm's length principle. And when we apply the arm's length principle, we compare the independent transactions with that of the related party transactions. And in comparing, we have the 5 methods, no, as required or given by the OECD transfer pricing guidelines. So we have 5 methods. We have the comparable uncontrolled price method, the resale price method, the cost plus method, transactional net profit method, and we have the profit split method. Hari. Okay. So when to use the comparable uncontrolled price method? Because as we have mentioned, in the OECD transfer pricing guidelines, we have the 5 methods. And in the United Nations Manual of Transfer Pricing, which is 2017 guidelines, United Nations Practical Manual on Transfer Pricing for Developing Countries, 2017 guidelines, meron naman silang 6 methods, no? Meron silang pang 6 methods, while yung OECD 5 methods lang. And yung number 1 nga dyan is the comparable uncontrolled price method. So we will discuss when to use the comparable uncontrolled price method. Kailan ba natin pwedeng gamitin at ano ba itong comparable uncontrolled price method, no? So, ang comparable uncontrolled price method, from the title itself lang, no? Anong kino-compare mo dyan? The price, no? So, ano sabi ng guidelines? The comparable uncontrolled price or the CAP method compares the price charged for property or services transferred in controlled transactions to the price charged for property or services transferred in comparable uncontrolled transaction in comparable circumstances. Kasi pag nag-compare tayo, dapat comparable yung circumstances. Hindi pwedeng mag-compare tayo na hindi sila pareho, no? The CAP method may also sometimes be used to determine the arm's length royalty for the use of an intangible assets. Pwedeng mag-compare ka na royalties. Ano ba yung royalties? Payment of the intangibles, which is, we will discuss in this case, no? Yung Redington India Limited, no? So, paano i-compare yung payment of royalties? Royalty is the payment for intangibles. No? So, CAP may be based on either internal comparable transaction or external comparable transactions. Pag sinabi po natin na internal transactions, yung transactions between related parties, no? Or samantala yung external naman, external transactions yan between independent parties. Okay, so the comparable uncontrolled price method compares the price. So, try to determine ano ba yung nandiyan sa price. Ano ba yung price? No? So, sino ba nagde-determine ng price ng isang product? No? So, yung price will cover the cost, no, of the product kasama na yung profit. Kaya nga, the best method, no, sabi ng OECD, the best method, kung available lang yung mga information lahat-lahat, the best method is the comparable and controlled price method. And what are the factors that will affect the price? No? Kasi sabi na natin dito, when to use the comparable and controlled price method. So, what are the factors that will affect the price na at that instance, yung gagamitin natin among the methods are the comparable and controlled price method. Ibig sabihin, ang gagamitin natin pag nag-compare tayo to apply the arm's length principle out of the 5 or 6 methods na sinasabi sa atin, bakit yung comparable and controlled price method ang gagamitin natin? Why? Because ang sabi po ng guidelines, the best method is the comparable and controlled price method. But when can we use the comparable and controlled price method? We can only use the comparable and controlled price methods if there is an available information. No? Ang problema mo, hindi ka makapag-compare ng price kasi nagtataguan ng presyo ang mga negosyante. No? Because ang price is a competitive advantage for the businessman, no? Kaya pagka nag-study ka, hindi basta-basta ibibigay sa iyo yung price ng businessmen, especially if they are your competitors, no? So when to use the comparable and controlled price method, you can use the comparable and controlled price method only if there are available information about the price of the comparable. No? Na-experience ko to lately, no, when I make a transfer pricing analysis and yung industry nung taxpayer ko is leasing. Ano yun? Nagpapaupa ng building and at the same time lupa, no? Anong klaseng lupa? What is the classification of the property? Industrial, no? So, ano yun? You have to compare the rent. Since ang lease is between related parties, then you are going to compare the price of the rent with that of the independent party. Eh kung hindi magbibigay yung mga neighboring lessors, no? So wala ka ngayong i-compare na price, no? Sana ko kumuha ng pang-compare ko na price sa advertisement. But of course, yung advertisement will not hold true in court. Ang binding dyan is the contract. Kasi offer lang yan eh. Yung nandyan sa dyaryo na makikita mo na the price per square meter is 200 pesos. So hindi pa yan. That is only an offer. No? So saan mo makikita yung totoong price? Nasa contract of lease. Eh kung hindi ka bibigyan ng contract of lease, then wala kang basis. So you cannot compare. You cannot use the comparable and controlled price method. So you can use only the comparable and controlled price method even if this is the most or the best method to use in transfer pricing. But you can use it only if there is an available information. No? Kasi mahirap magbigay ng information ang competitors. No? Okay. In applying the CAP method, no, sabi ng guidelines, determine whether the price charged in controlled transaction is at arm's length. No? So, i-determine mo kung yung price charge is arm's length, which is the very purpose of transfer pricing. That's why yung sabi nga, the heart of transfer pricing is comparability analysis. Why? Because we are going to compare the price of the related party transactions with that of the independent party transactions, because the purpose there is to bring the related party transactions at par or the same with that of the independent transactions, because the true transaction is that of the independent party transactions. Why? Because there is no element of control. Ang related parties may element of control, kaya that is not a true transaction. That is an artificial price. No? Okay. So when applying the CAP method, an uncontrolled transaction is considered comparable to a controlled transaction if there are no differences in the transaction being compared that would materially affect the price. So, pwede ka lang gumamit ng comparable uncontrolled price method if wala raw differences in the transaction. So, you have to look for a transaction which is the same with that of the related party transactions na kinukompare mo. Reasonably accurate adjustment can be performed to account for material differences. Halimbawa naman, hindi talaga sila parehong-pareho. Pwede pa rin gamitin mo siyang comparable, but you have to adjust, no? Ano yun? Whatever differences na meron can be adjusted to bring them to be similar, no? So, matanggal mo, maalis mo yung differences. So, reasonably accurate adjustment can be performed to account for material differences between the controlled and the uncontrolled transactions. So, pwede kang mag-adjust to eliminate or to remove the differences, no? So, yan po yung sa CAP method. And what are the factors that affect the price, no? So, yung number one talaga that affects the price are the characteristics or nature of the business. Why? Kasi, mag-iba lang ng konti yung characteristic ng product or services, mag-iiba na yung price, no? So, characteristics or nature of the services will influence the price, no? So, what are the factors that should be taken into account when you compare? Number one, characteristic of the property being transferred or services provided. Number two, contractual terms, no? Kung may contracts. So, you can also look at the provision of the contracts, kung bakit sila magkaiba. There might be some provisions na may iba pang considerations, no? Kaya nagkaiba ng price. Number three, economic conditions. Economic conditions, especially sa during the pandemic, iba yung conditions natin economically, no? Hindi ko ma-explain anong klase itong nangyayari sa atin, but there is an economic struggle during the pandemic. And then number four, business strategies, no? So, for the functional analysis, it is necessary to analyze the functions performed, the risk assumed, and the assets used. Why? Because that will also affect the price. Halimbawa, yung functions, iba ang piniperform, so iba yung price ng services. Or, the risk assumed, no? May mga warranties halimbawa na kasama. So, iba yung presyo ng product. Excuse me. And the assets used. Pakipatay na nga itong, tapos isindi yun doon. Kasi diretso sa akin. Sisinghot ko yung hangin galing sa aircon. Okay. So, in the example, no? Kasi ngayon, dati, puro OECD transfer pricing guidelines yung ginagamit ko pag na-discuss. Ngayon, ginagamit ko itong practical manual and transfer pricing. No? So, ano yung mga sinasabi dito sa transfer pricing manual ng United Nations? Kung ano yung mga factors that will affect, no? The price, no? So, ano daw yung mga factors that will affect the price? The type and quality of the products, no? Halimbawa, branded yung isang product, yung isa hindi, no? O kaya yung durability, no? Yung quality ng product. Yung isa ang gamit niya na raw materials is yung poor quality, yung isa naman good quality. So, mas durable yung isa. Of course, magkakaroon ng difference sa price, no? Delivery term, no? Ano yung mga example ng delivery term? Halimbawa sa delivery, FOB, no, print on board, o kaya yung delivery mo na COD, no? So, iba ang presyo niyan. Another is volume of sales and related discounts. Halimbawa naman sa sales, bakit daw nagkakaiba ang presyo? Because of the volume of sales. Siyempre, pag bumili ka ng marami, may discount yun. O kaya may volume discount, no? Kaya mas mura yung product. Another is product characteristics. No? So, na-explain ko na sa inyo itong product characteristics. Pag durable, pag magandang klase, maganda yung workmanship, syempre mas mahal. Contractual terms. Itong contractual terms, halimbawa 90-day na credit term or 120 days or 30 days or cash. Syempre iba yung cash. May cash discount yun. Samantalang yung term, meron ng something like interest na ipapatong na doon sa price of the product kasi matagal mong bayaran, no? Risk in card. So what are the risk in card? Pwede yung warranty of the product na masira yung product, no? So those are the risk na magkaroon ka ng after sales na services. Why? O kaya babayaran mo kung masira, papalitan mo yung product, no? So those are the risks that will also affect the price. And also the geographical factors, yung location, kung saan i-deliver yung product o saan nangyayari yung transactions, the geographical factor can also be considered in pricing the product. No? Okay. Unique and valuable trademarks. So ito pa, pagka branded yung product mo, kaya nga ito yung case dito sa Redington India Limited that we will discuss. Pagka unique and valuable yung trademark mo, ibig sabihin, meron niyang pangalan, no? And then yung pangalan niya sikat na, and then pagka narinig mo yung pangalan, parang nakakabit na dyan yung quality ng product, maganda yung klase. So, may presyo yan, no? Kaya ngayon sinasabi nila na branded. Okay, so fundamental differences in the product, if the product being sold are significantly different from the product sold in the proposed comparable transaction, it may not be possible to adjust for the product differences. Pagka ang product na you are supposed to compare is ibang-iba talaga doon sa product under study, then you have to eliminate that comparables. Hindi sila pwedeng i-compare. No? So, hindi kasi ibig sabihin na pag nag-compare ka, lahat na lang ng product pwede mong i-compare. Hindi po. No? There are products talaga na hindi sila comparable. No? So, what are the strengths and weaknesses of the CAP method? No? CAP method is a two-sided analysis, as the price used reflect the agreed price between two unrelated parties to the transactions. Bakit siya two-sided analysis? Kasi meron siyang buyer and may seller, no? Kaya dalawa silang unrelated parties to the transactions. And then avoids the issue of which of the related parties involved in the control transaction should be treated as the tested party for transfer pricing purposes, no? So wala siyang related parties, no? Kung kagaya ng mga one-sided analysis, cost plus method, related parties, cost plus method, the resale price method, the transactional net margin method, those are one-sided analysis. Kailangan yun ng tested party. Sa comparable uncontrolled price method, this is a two-sided analysis. Hindi na po kailangan ang tested party dito. No? So, ano pa yung strength and weaknesses niya? Involves a direct transactional comparison of a similar transaction between unrelated parties. No? So, it is more direct measure of the arm's length price than the other methods, all of which indirectly determines the arm's length price. Ang comparable uncontrolled price, or when you compare the price, that is a direct method. Kasi price to price talaga. So anong ibig sabihin yun? Product to product talaga ang kino-compare mo. Unlike sa ibang method na gross profit lang, so estimate na lang. Hindi na niya sariling price, no? Price na nung group of product na binenta. Okay. As it is more direct measure, the CAP method is less susceptible to differences in non-transfer pricing factors. Kaya nga, pareho talaga pagka ginamit mo yung comparable uncontrolled price method, dapat the same talaga yung product. Another is maybe more readily used in instances such as, for example, transactions involving commodity products. Kaya nga yung case na the most controversial case in transfer pricing so far, which is the case of the GlaxoSmithKline, they use the comparable uncontrolled price method. Why? They compare the price of the GlaxoSmithKline, yun, internal comparables pa yung ginamit nila. Paano yun? They compare the price of the active ingredients of the Santac, which is the product, no? Isang product lang yung kinumpare nila, which is the number 1 sellable sa Canada. So what do they compare? Kinumpare nila yung price of the active ingredients of the Santac, no? So anong nangyari? Internal comparables. They compare the price of the active ingredients between the product sold in Canada and that same product sold by the group to another related party in other countries just like Egypt and in the Europe, no? So doon nila nakita na napakalaki ng diferensya ng price, no? Even if you adjust for a geographic location, malaking-malaki pa rin, no? So doon na natalo yung GlaxoSmithKline, and they use the comparable uncontrolled price method. So when they use the comparable uncontrolled price method, when comparable uncontrolled transactions can be found, syempre, kasi kung walang information about the uncontrolled transactions, then mahirapan po tayo gumamit ng CAP method, no? Okay. So another topic that we will discuss tonight is the discounted cash flow method of valuing intangibles. Ano po itong discounted cash flow? At ano itong valuation of intangibles? So when we say intangibles, these are assets, no? Intangible assets are assets that cannot be seen or cannot be touched, no? But they are very valuable. Ano yung mga intangibles na examples natin? Ito yung mga trademarks, copyrights, no? Even business name. Our business name, pagka sikat na, they are already intangibles, no? They have no physical attributes, but they are value drivers of the business, no? Okay. How are we going to value the intangibles? Ang intangibles po, iba-ibang paraan ang pagbavalue. Although, ang isang problema natin dito sa Pilipinas is that halos wala pa tayong nakikita mga intangibles in the balance sheet. Kasi hindi pa masyado nire-recognize ang intangibles in our balance sheet, unlike in other countries, no? Just like Europe and the United States, very important na po sa kanila ang intangibles. Also, yung Malaysia, no? Sa mga loan sa bangko, ginagamit na po nila na basis yung mga intangibles to determine the loanable amount or value of the company. No? Sa atin hindi pa masyado. And paano ba binavalue yung intangibles? Pagka ang intangibles mo is nakuha mo siya o na-develop mo siya through research and development, then usually, yung ibang valuation is through the cost, no? So, paano mo i-value yung intangible through the cost? How much is the cost to develop? Halimbawa, nag-develop ka ng software. So, pina-outsource mo, pina-develop mo sa mga service provider. how much is the cost na ginamit mo. So, cost can be determinant for the valuation of intangibles. But, sa actual, hindi pumapayag na ang tax authorities that you use only the cost method in valuing intangibles. Why? Because that is not the actual value of intangibles. Why? Because just like halimbawa, nag-develop ka ng software, the cost is 1 million. Nung binenta mo na yung software o ni-license mo na yung software, ang expected na kikitain mo for 10 years is 100 million. So, ibig sabihin, hindi napakalayo or hindi relevant doon sa talagang totoong value ng intangibles, yung cost incurred in developing the intangibles. No? Kaya may tinatawag tayo na income approach at dito sa case na i-discuss natin is the discounted cash flow method of valuing intangibles. No? So, ano yung discounted cash flow method? Okay. So, where reliable, comparable, and controlled transactions cannot be identified, it may be possible under certain circumstances to use valuation techniques to help determine the arm's length price for intangibles transferred between associated enterprises. Actually, dito yung mga cases on intangibles na nakakarating sa korte. At ano yung pinag-aawayan sa court? The valuation of intangibles. No? Just like the DHL case, the Veritas case, the Amazon case, ano yung pinag-aawayan doon? The valuation of intangibles. No? Kasi ang valuation ng tax authority napakataas. Ang valuation naman ng taxpayer is napakababa. Why? Because they are paying the income tax based on the value of intangibles that they transferred. No? So, doon nagkakatalo sa value. Okay. So, kailan ginagamit yung discounted cash flow methods? The application of valuation techniques based on the calculation of the discounted value o projected future income. Kasi pag sinabi mo discounted value, mayroon kang projected na future income. Ito na yung ina-anticipate mo, magkano yung kikitain ng intangibles na na-develop mo. Ito yung tinatawag na projected future income streams or discounted cash flow. Derived from the exploitation of the intangibles being valued may be useful. But it is depending on the facts and circumstances. Valuation techniques may be used by taxpayer and tax administration as part of one of the method described. No? So, ang karamihan, the method used by the tax authority is different from the method used by the taxpayer. Kaya sila hindi magkasundo. So, it's up for the court to decide. Kasi dinadala na sa court ang case. No? Circumstances in which a discounted cash flow approach might be appropriate. Kailan daw appropriate yung discounted cash flow methods, no? Pero, ano ba yung discounted cash flow method? Discounted cash flow methods are typically based on projection of cash flows. From the title lang niya, no? Na discounted cash flow. So, ano ang ibig sabihin niya? Based on projections of cash flow. Ano yung cash flow? Yung possible na kikitain niya, no? So, accrual-based measures of income may not properly reflect the timing of cash flows, which can create a different outcome between an income and cash flow based on approach. Kaya kaso lang, since pag sinabi mong discounted cash flow, meron kang projections. Pag sinabi mong projections, hindi pa nangyayari. No? Estimate pa lang. No? At posible na mangyayari yun, posible din na hindi. Pwedeng lalagpas pa doon sa projection na yun, pwede rin mas maliit. No? The use of income projection rather than cash flow projections may, in some cases, yield a more reliable result in a transfer pricing context as a practical matter. No? Lakas na ulan, ah. Okay. So, kailan po natin pwedeng gamitin itong discounted cash flow na method? sa pag-value po ng intangibles. A discounted cash flow analysis may be undertaken by taxpayer or tax administration. So, pwede yung taxpayer, pwede rin yung tax authority, no? At a time subsequent to the intangible transfer. Kasi kailan ba nagkakaroon ng issue ang valuation ng intangibles? At the time na i-transfer mo na siya, no? Kasi kung nandiyan lang siya sa balance sheet, hindi ginagamit lang siya, wala pong issue sa valuation at the time of transfer, no? In order to inform the analysis of the value of the intangible at the time of the transfer, but the reliability approach may be reduced, no? Lalo-lalo na yung discounted cash flow method is based on assumptions pa lang, no? Kaya pwede pa siya i-challenge, pwede pa siyang i-question, no? Undiscounted cash flow method, which is in the case of this Redington India Limited. No? So, may mga explanations actually dito sa guidelines, no? But that is not our discussion. Kasi ang discounted cash flow method or the methods to value intangibles, napakahaba pong topic yan. No? Kung baga sa pahapyaw lang natin yan na diniscuss dito ngayon because this is part of the issue that's settled in this case of Redington, India. Okay. Walang shout out. Ilan yung ating Ha? 4. Sige. Wala na kasi kinakalimutan na naman ang transfer pricing kasi hindi na nire-require sa 1709. Maalala na naman ulit yung transfer pricing pag na-audit na. Pag may transfer pricing audit na. Ganun lang. Okay. But tayo, tuloy lang po tayo sa discussions natin in transfer pricing because di naman natin alam anytime kailan ka ma-subject into a transfer pricing audit. No? So, our case for tonight is the Principal Commissioner of Income Tax versus the Redington India Limited. No? So, ito yung case. At saan po siya? Sa High Court of Judicature at Madras. So, sa Supreme Court na rin to. Kasi High Court na siya Galing siya sa Income Tax Appellate Tribunal. So, galing na siya sa appeal. No? Dinala na pala siya sa higher court. Okay. So, this appeal have been filed at the revenue under Section 266A of the Income Tax Act of 1961. Alam niyo po, ang India is very good in transfer pricing. In fact, in early years, mga 2000 pa, no? Say, started studying transfer pricing in 2008. And during that time, nakakasabayan ko yung mga Indiano na mga classmates ko nag-aaral ng transfer pricing, magagaling na sila. No? I updated my study in 2016. Ganun pa rin sila. Napakagaling ng mga transfer pricing officers nila. No? And yun na nga, one transfer pricing officer in India can resolve transfer pricing cases as much as 18 cases a day. No, you can just imagine that 18 cases a day. Ang bilis-bilis mo nung i-resolve. Pero kung basahin mo yung case, sa case pa lang, yung fast of the case pa lang, tagal-tagal na yan, yun pang 18 cases i-decide mo. Pero sabi naman nung classmate ko, mabilis lang daw sa kanila because titingnan lang naman nila daw yung issue At saka kung ano daw yung method na ginamit, doon lang sila nagpo-focus, hindi na sa facts of the case. Halimbawa, yung ginamit na method nung taxpayer is cost plus method. So gross profit, yung didebatehan na lang nila, ano ba yung arm's length na gross profit? No? And usually, panalo ang tax authority pagdating na sa court sa transfer pricing. But, alam nyo na, yung sabi na nga, ang mundo umiikot, pagdating ng nag-iba na yung administration sa India, wala na, nagbago ang batas ng transfer pricing. Kaya ngayon, balik sila sa dati. Hindi sila makakapag-enforce ng kanilang mga findings kasi nag-amend yung batas sa India, no? Less authority na lang binigay sa mga transfer pricing officers, no? Nakakalungkot, but ganun ang buhay sa mundo eh. So kung ano yun na dyan, susunod tayo. Although talagang magagaling sila, no? And they have collected so much in transfer pricing cases. No? Okay. So the appeals were admitted and consider the following substantial questions. Ito yung mga issues doon sa appeal. No? Number 1, whether the income tax appellate tribunal or the ITAT was right. No? Tama ba in applying the general provision law, ignoring ito na po yung mga issues kasi appeal na to, no? Hindi na to yung umpisa pa tayo sa facts of the case na pag lower court kasi factual ang pinag-uusapan. Pagdating na sa appeal, sa higher court na, ang pinag-uusapan dito issues na, no? So ito yung mga issues na pinag-uusapan, yun yung number 1. Whether the income tax appellate tribunal was right in applying the provision law, ignoring the specific provisions of subsection 47.4 and holding that the transfer of shares by the assessee to its wholly owned subsidiary is to be considered as a gift. Kasi bakit? Ano nangyari dito? Tinransfer niya yung kanyang shares of stocks without any consideration. So, kinonsider siya ng gift. At alam nyo naman, ang gift is taxable. No? Si transfer tax yan. Number 2, whether the order of the income tax appellate tribunal upholding the decision of the dispute resolution panel in granting 10% risk adjustment allowance is not perverse. Kasi dumaan na sila sa yung dispute resolution, yung panel, no? Ibig sabihin, hindi sila magkasundo. So dumaan na sila doon sa pinagkakasundo na sila. And there is a 10% adjustment granted by the dispute resolution panel. Ayaw ng Redington, India. Kaya siya nag-appeal. No? So whether the order of the income tax appellate tribunal in allowing the claim of trademark, so ito na yung intangibles, no? Trademark. Bakit the intangibles and trademark? Because it is an asset with no physical attributes, but it has a value to the product. At ano yung value niya sa product? Yung trademark na nakakabit dun sa product, yan yung nagbibigay ng value to the product. Why? Kasi pagka nakita ng customer, ito yung trademark na to, may significance yan or may sign niya na magandang klase itong product na to. Or the trademark carries with it guarantee na maganda yung product. At since may mga sikat na yan, may mga gumamit ng mga ganyang product, hinahanap na nila yung trademark na yan in the market. No? So, claim of trademark fee and deleting the addition on account of corporate and bank guarantee are not perverse. Kasi yung claim ng trademark, no? Kung tama lang ba. The assessee filed its return of income for the assessment year under consideration 2009-2010, no? Admitting taxable income of 125 iba tong pera ng ng India, no? So, dali lang. Kasi bibilangin ko kung magkano ito, no? Crore, no? So, 125 crore, 57,70,310. So, yun po yung assessment, no? The return was processed under Section 1431 of the Act. Subsequently, the case was selected for scrutiny on the ground that the assessee had international transactions exceeding 15 crores. No? So may threshold sila. And the case was referred to the transfer pricing officer. So, may transfer pricing issue. Kasi sa ibang bansa, meron talaga ibang division ang nag-handle po ng transfer pricing. Meron silang International Tax Division o meron silang Transfer Pricing Division. No, sila yung nag-handle ng transfer pricing. And ang mangyayari diyan, pag may issue about transfer pricing, i-refer doon yung case. No? Unlike dito sa Pilipinas, na yung transfer pricing audit dito is also handled by the examiners handling regular audit. Kaya ang transfer pricing audit po dito is kasama sa regular audit. Kaya pag sinabi mong all internal revenue taxes yung under audit mo, kasama na rin doon yung transfer pricing. So there is no specific letter of authority issued to the taxpayer to conduct a transfer pricing audit. Basta't binigyan ka ng letter of authority for a regular audit, kasama na dyan yung transfer pricing. No? Okay. So, anong ginawa dito? The case was referred to the transfer pricing officer for computation of arm's length price. After hearing the assessee, the draft assessment order was passed proposing the following additions or disallowance. No? So, ito yung mga disallowances proposed in the draft order or ito yung assessment. No? So, LTCG adjustment determined by the TPO or Transfer Pricing Officer. Magkano to? 610 crore, 15,75,820. Corporate and bank guarantee charges. No, adjustments suggested by the Transfer Pricing Officer again. No, ito yung mga corporate and bank guarantee charges. 9 crore, 28,73,000. Trademark and license fees. Ito, sa Transfer Pricing Officer pa rin to. 1 crore, 89,33,150. Bad debts, 3 crore, 25,47,000. No? So, factoring charges, ano tong factoring charges? Usually sa accounts receivable ito or sa interest, no? Kita to ng accounts receivable. Or financing. 17 crore, 7,56,151. Yun yung disallowance ng factoring charges. No? So, agreed by the draft assessment order, the assessee filed their objection in Form 35A. Sino yung appellant dito? The Commissioner of Income Tax. Sino yung respondent? The Redington India Limited. Okay. Okay. So, agreed by the draft assessment order, the assessee filed their objection in Form 35A, which was forwarded to the Dispute Resolution Panel, Chinay, DRP, by the assessing officer. The DRP heard the assessee issue directions under Section 144. In terms of the direction issue, the assessment was completed under Section 143 of the Act, raising a demand of 204.51 crores. The assessee filed the rectification application before the DRP or Dispute Resolution Panel. The said application was considered and modified. Directions were issued in 2014 by deleting the additions on disallowance of factoring charges and bad debts. So, tinanggal yung factoring charges and bad debts. Magkano yung factoring? 17 crores. Ang bad debts, 3 crores. No? Sa atin, ang crores, magkano yan? Billion. No? Kasi ang 1,000, tapos ang sunod dyan, million. Sunod pa yan sa million. Ang lakh is million, tapos ang crore is billion. No? Sige. Okay. Both the assessee and the revenue preferred appeal to the tribunal. Nag-appeal sila, pareho. The tribunal deleted the disallowance of corporate and bank guarantee. So, unti-unti na tatanggal yung mga assessment, no? So, tinanggal na naman yung corporate and bank guarantees, na tanggal na yung factoring charges at saka bad debts. Tanggal na naman yung corporate and bank guarantees. Okay. on the ground that it does not have any bearing on profits, income, loss, or assets of the assessee. No? So yun ang reason. The disallowance of trademark and license fee was also deleted. No? Tinanggal din. Holding that there is nothing uncommon in the assessee making payments to use of the trademark. Remember, ang binabasa ko sa inyo ngayon is the decision of the appellate court. No? Sa income tax appeal tribunal. Hindi pato yung decision na dinala na nila sa Supreme Court. Hindi. Di pa yan. Kasi pagdating sa Supreme Court, iba po ang decision. Okay. The disallowance of trademark and license fee was also deleted, holding that there is nothing uncommon in the assessees making payment to use of the trademark to Redington Distribution Limited, Singapore. Kasi related parties to, so may group of companies involved. With regard to the disallowance of long-term capital gain adjustment, the tribunal held that a transfer of shares made by the assessee without consideration, imagine ilang number of shares itong tinransfer nila without any consideration. So, ibig sabihin for free, no? Was a valid gift. So, anong tawag mo dyan? Pagka ang isang bagay na napakalaki, binigay mo lang o tinransfer mo without consideration. So, anong tawag mo doon? Valid gift, no? Gift siya. Bigay lang. And the transfer of shares cannot be regarded transfer for capital gains taxation as provided in Section 47 of the Act. The tribunal accepted the contention raised by the assessee that the transfer of shares made by the assessee to its step-down subsidiary Redington International Holdings Limited, Cayman. No, ito yung mga companies na nasa Cayman Island, no? Which is a tax haven country. Is gift eligible for exemption under Section 47 of the Act, and no capital gain tax is imputable to the said transfer of shares. So meron silang pinanghahawakan na batas na yung tinransfer nilang shares of stocks hindi taxable, walang capital gains. Why? Kasi kahit ito sa atin, di ba, merong binabayaran pagka nag-transfer ka ng shares of stocks, no? Ang tawag doon is capital gains, no? That you are going to pay on the sale of shares of stocks. Okay. The revenue appeal was dismissed in its entirety. So, anong ginawa dito ng income tax tribunal? Income tax appeal, no? Talagang dinismiss niya yung appeal ng tax authority in its entirety. So, talo dito sa appeal na to ang tax authority. So, challenging the order of the tribunal, the revenue is before us by way of the tax case appeal. So, anong ginawa na ang tax authority? Nag-appeal siya sa Supreme Court, no? Okay. Ms. R. Himalata, learned senior standing counsel for the revenue, submitted that the assessee had transferred without consideration. So, anong contention ng tax authority o yung pinaka-BIR nila? Sabi nga, the Redington daw transfer it in its entirety, its entire holdings in Redington Golf FCA to RC on RC, ito yung sa Cayman Island, no? Ito yung Redington International Holdings Limited, Cayman, or RC in short, no? So, yung shares of stocks ng Redington Golf FCA, tinransfer niya sa Redington, Cayman, no? On November 13, 2008, and within a very short period of less than a week, no? Less than a week. A private equity fund investment corporation invested $65 million in the assets overseas. Excuse me. Maganda yung case na to eh, kaso lang, nauubo ako eh. Ano yung aircon? I-sound pa rin. Okay. Sige. Okay, balik po tayo, no? Kasi this is a very good case, no? Pero mo, anong ginawa dito ng Redington Cayman, no? Redington Golf FCE, tinransfer niya yung entire holding niya sa Redington Cayman, okay? And on a very short period, less than a week, a private equity fund investment corporation invested $65 million in the assessee overseas step-down subsidiary. Ito yung Redington International Holding Limited for 27.17 stake and claim it as a gift. No? And claim exemption under Section 47 of the Act. It is submitted. The transfer of shares by the assessee is not a gift falling under Section 47. Ito naman yung contention ng tax authority. Hindi siya gift, no? For the reason that the assessee transferred the shares only by way of restructuring the company investment in RGF. The learned counsel referred to the minutes of the board meeting as well as deed of share transfer and submit that neither in the minutes of the board meeting nor in the share transfer deed the word gift has been mentioned, and the document shows that the entire transaction is in the form of restructuring the assessee. So ito ang learned natin sa mga cases, no, na may deliberation na sa court. Ano ginamit nila dito? Yung minutes of the board meeting. Why? Kasi 'di ba pagka may meeting ang board, may minutes siya, naka-record yan sa books, no? That's why if may mga transactions na nangyayari approved by the board, babalikan yung minutes kung ano yung purpose, kung paano nila, ano yung deliberation during the time na gumawa sila ng ganitong desisyon. And in this case, ito yung ginamit nila, yung record during the board meeting ng board of directors ng corporations nung nilipat nila ang shares of stocks, no? So anong sabi nung learned counsel ng tax authority? Wala silang sinasabi during the board meeting na ang shares of stocks ita-transfer nila by way of gift. Ano yung sabi nila? The shares of stocks is in the form of restructuring. So business restructuring pala. Binago nila or doon sila nagbigay ng shares of stocks nila o nag-invest sila doon sa isang company. So further, it is submitted that the board resolution towards restructuring the concern of the board be and hereby accorded to transfer the investment. So yun pala ang purpose. Transfer the investment held by the company in RGTF to intersea subsidiary companies with or without consideration. So yun yung purpose nila. With or without consideration, ilipat yung investment. Kasi ang shares of stocks po, yung investment mo sa shares of stocks is an investment. So, capital yan eh. So, paano yung kumikita? In the form of dividend. Thus, it is submitted that the words clearly show that the transfer is not by way of gift but for restructuring the company. And alam naman natin that business restructuring is a very important issue in transfer pricing, no? Pag nag-restructure ka ng business, why? Because what will happen during the business restructuring? May mga changes, no? And during the restructuring, there can be a change in functions, assets, risk. So, ito yung nangyari dito sa case na to. So, furthermore, the concept of gift was never in the minds of the assessee when the resolution was passed. by the board or while transferring the shares. No? So wala daw sa isip nila yung salitang gift or bigay. It is submitted that restructuring of the assessee would fall under Section 47.4 or Section 47.5 of the Act, and there is a specific condition that the subsidiary company should be an Indian company. No? So yun ang mga conditions. Ililipat nila yung shares of stocks. Insofar as transaction done by the assessee is concerned, the subsidiary company is a non-resident and therefore the assessee had violated the condition stipulated under Section 47.4. Alam niyo, very important yung mga provisions. Why? Kasi pagka ang provisions na pinag-usapan, hindi napasok dyan yung transactions mo, of course, hindi ka pwedeng sumilong or gamitin yung provision na yan para sa exemption mo sa tax, no? So, yun ang nangyari dito. Kaya ano sabi ng tax authority? Hindi siya qualified sa Section 47.4, no? Or Section 47.5 of the Act. Consequently, the assessee is liable for capital gains since hindi siya violated siya yung conditions ng Section 47.4 and Section 47.5 na ang sabi diyan dapat Indian company. Eh, anong nangyari sa kanila? Non-resident yung pinaglipatan nila ng shares. No? So, it's liable for capital gains under Section 45 of the Act as the transaction would fall within the definition transfer. So, transfer, hindi gift. As defined under Section 247 of the Act, further, it is submitted that the transaction done by the assessee would clearly fall under Clause E of Explanation to Section 92B of the Act, which states that the transaction of business restructuring or reorganization entered into by an enterprise with an associated enterprise irrespective of the fact that it has bearing on the profit, income, losses, or assets of such enterprise at the time of the transaction or at any future date. The transaction done by the assessee should clearly fall within the said provision, the horse, whether it has bearing on profits, income, loss, or assets of the company. Further, it is submitted that when there is a specific provision in respect of restructuring the organization of the company falling under the category of international transaction, such provision shall override other normal provisions of the Act. Oh? Kasi pumasok na dito yung international transaction dahil foreign yung company na pinaglipatan. Irrespective of the fact that it has bearing on the profit, income, loss, or assets of such enterprise at the time of the transaction or at any future date. So in this regard, the learned counsel placed reliance on the circular issued by the Central Board of Direct Taxes. In Circular number 14, 2001, dated 9/11/2001. Okay. The circular, it is the submission that the legislation has amended the Act to curb tax avoidance by abuse of transfer pricing. Kaya nga nag-a-amend ng mga batas itong ibang bansa, just like sabi ko, ang India, ang ganda ng kanilang transfer pricing laws, kaya nakakakolekta sila ng malaki sa transfer pricing. No? So in this regard, reliance was placed on the ruling of the authority for advanced ruling in the case of Reorient Green Power Limited 2012. So it is further submitted that assuming for the sake of arguments that the transfer of share to the entity abroad is a gift which should satisfy the conditions stipulated in Section 122 of the Transfer of Property Act. No? And the necessary ingredients being that such transfer should be voluntary, should be without consideration, and there should be acceptance by or on behalf of the donee. It is submitted that the transaction done by the assessee is not a voluntary transaction, kaya hindi siya qualified na magiging gift, which has been brought out in the findings of the TPO in paragraph 17.23 of the order. So, ano yung pinag-aawayan nila dito? At saka yung nangyari pa dito na nagkaroon ng 27.17% stake ang PE investors, no? And then compel them to do so on the transaction owing to such compulsion or enforcement placed by the investment corporation takes away the element of voluntariness in the transaction. Pag sinabi mo kasi na voluntary, magiging qualified siya doon sa meaning ng gift, no? So, pinatunayan lang dito ng transfer pricing officer na hindi na voluntary yung ginagawa ng Redington, no? So, the learned counsel has referred to the findings rendered by the TPO in paragraph 17.2.5. It is stated that the CFO himself, no, yung Chief Finance Officer, admitted that the cross-border transaction was structured for business reasons for deriving commercial benefits. It is submitted that the transaction is not voluntary, no? Kasi pinag-aawayan lang naman nila dito kung gift ba o hindi. So, talagang yung allegations nila na it is not voluntary, it was done with certain expectations from the receiver and therefore does not qualify as gift, no? So, the learned counsel referred to the findings of the TPO as to how, in a cogent manner, finding has been rendered, no? So, the Redington Golf shares has been disposed of for valuable consideration per the audited balance sheet. Oh, so ito pa, na lumabas sa balance sheet. Kaya yung mga financial statements natin, they are very important source of information, especially during the audit, no? Of the assessee company itself, and such transaction which is backed by consideration cannot qualify as gift with regard to the third requirement, no? Acceptance by Donny company does not been established by the assessee by producing any documentary evidence to said effect. None of the three conditions laid down in Section 122 of the TP Act has been fulfilled, and therefore the transaction is not a gift, no? So hindi gift yung transaction. In support of the above contention, reliance was placed on the decision in the case of Boeing versus CIT. Oh? So yun po yung isang issue, and na hindi gift yung binigay nila o transfer nila yung malaking shares of stocks. Okay. Mahaba ito pero hindi naman natin ito kasi mga ano na to. Dito tayo hari sa page, ano na ba to? Dito sa number 11. Kita mo? 13, page 13. Kita mo? Number 11, the tribunal deleted the disallowance of corporate and bank guarantee charges. Ito yung findings ng TPO, no, on corporate and bank charges. No? So, diniscuss din dito bakit na dinilit siya. No? Kasi doon sa tribunal, lahat ng findings ng TPO, inano nila ng transfer pricing officer, parang winalabisan nila, no? So, ni-review siya ng higher court. The tribunal deleted the disallowance of corporate and bank guarantee charges without considering the legal position that such transaction is taxable. No? Dinilit lang niya, pero hindi niya inisip na taxable siya under capital financing, including any type of long-term and short-term borrowing, lending, or guarantee purchase or sale of marketable securities or any type of advance payments or deferred payment or receivable. Dinilit niya, pero taxable yung transactions, no? Or deferred payment or receivable or any other debt arising during the course of business, as could be seen from the clause A in explanation 1 to section 92B, and would fall within the expression international transaction. So taxable siya. In support of such contention, reliance was placed on the decision of the Hyderabad Tribunal in Prolifix Corporation versus DCIT. With regards to disallowance of trademark, ito na yung mga disallowance no? So yung disallowance nila on the bank charges, yung gift, tapos ito namang trademark, no? And license fee, which was deleted by the tribunal. It is submitted that the assessee had made an application on February 29, 2000 for registering the trademark and obtained the certificate of registration on March 17, 2009. No? So the agreement between the assessee and Redington Singapore was on June 1, 2006, and the assessee was using the trademark from 1993 onwards. No? So mayroon ng trademark at ginagamit na nung assessee 1993 onwards. The Singapore entity was formed only in the year 2005, whereas the Indian entity was established in 1993. So, matagal na niyang ginagamit. And much before the said company was formed, they were using the word Redington for their products sold in India. Kasi ang trademark dito is Redington, no? The assessee has not placed any material to controvert this factual position. The certificate of registration granted by the trademark registry though issued only in 2009, it is deemed to have been granted from the date of application. Kailan siya nag-apply? 2000 pa, no? February 29, 2000, leap year, no? So, nag-apply siya noong 2000, na-approve ng 2009. So, ginagamit na 1993 pa, no? So, anong sabi dito? It is deemed to have been granted from the date of application. That is, from the year 2000 onwards. No? So, in terms of Section 23 of the Trademark Act 1999, yan ang trademark law nila or intellectual property law nila sa India. So, therefore, the tribunal committed an error in permitting the assessee for adjustment of the license fee for use of the trademark to the subsidiary company which was formed much later in point of time. So, nagkamali yung tribunal. Ito during the review na ng higher court. So, in this regard, the learned counsel has drawn the attention of this court to the trademark license granted to the assessee. Therefore, there was absolutely no necessity for payment of any license fee, and the tribunal ought not to have interfered with the order passed by the TPO disallowing the said claim. So with the above submission, the learned senior standing counsel prayed for allowing the tax case appeals and answering the substantial question of law frame in favor of the revenue. Sa totoo lang, ang decision po dito in favor of the tax authority, no? So, Mr. Percy Pardiwala, learned senior counsel assisted by Mr. Invi Balaji, learned counsel appearing for the assessee. Ito naman yung mga legal counsel ng Redington, no? After elaborating to the factual matrix as well as the pictorial representation of the transaction, which was depicted in the order of the TPO and also in the written submission made by the respondent, submitted that the assessee Redington India Limited, or RI, is a company incorporated in India and its shares are listed in the Bombay Stock Exchange and the National Stock Exchange. So, ibig sabihin, itong Redington India Limited is listed, no? Ang kanyang shares of stocks listed. Bakit? Kasi nasa Bombay Stock Exchange and the National Stock Exchange. No? So, listed ang shares of stocks niya. The overseas operation of the assessee in Middle East and Africa is carried on through the assessee's wholly owned subsidiary, Redington Gulf FZE, or RG, which has 16 subsidiaries. No? So, group of companies po ito, which has 16 subsidiaries located in several countries in the Middle East and Africa. It is submitted that the assessee had intention of expanding its base and footprint in the Middle East and Africa, which required additional funds in the hand of RG and RI, also intended to list the Middle East and Africa business on an overseas stock exchange. No? So, ngayon, paramihan na ng company sa Africa, no? Kahit yung mga internet companies, nandun na, they're investing so much in Africa. Why? Dahil napakalaki ng Africa, napakalaki ng market nila. No? And even China is also there. Para anuhan sila ng sa Africa ngayon. No? Paramihan ng investment. Okay. on an overseas stock exchange. It is submitted that during 2008, a private equity fund, InvestCorp, events interest in investing in the Middle East and Africa operations of the assessee. RG is established in a free zone enterprise within the Jebel Ali Free Zone Authority, Dubai. Yung company natin na nagpagawa sa atin ng 1709. Ito yun. Jebel Ali Free Zone Authority sa Dubai. Ano to? Ito yung parang pesa nila. Economic zone. No? So, meron tayong company dyan na dyan, yung buksan mo yung lahat ng pinto para pumasok yung hangin. Napakainit na pero ayoko ng aircon. No? Ano mo tong ito, ventilador. Buksan mo pero doon lang. Paano mo doon? Sige. Kasi Makati sa lalamunan yung init ng aircon. Hangin. Buksan mo yung pinto doon para pumasok yung hangin. Okay. Okay. Ano yung advantages pagka nasa free zone, no? Nasa economic zone ang company? They are paying preferential rate in terms of taxes. No? In the Philippines, magkano yung preferential rate of taxes paid if you are PESA registered enterprise or you are in the economic zone? You are going to pay only 5% in lieu of all taxes. No? Okay. So, and the regulations governing establishment and operations of the companies within the said free zone authority does not permit more than one shareholder in a free zone enterprise. Thus, it is submitted that it was not possible in IVC to directly invest in RJ due to single shareholder restriction. Therefore, the assessee is stated to have undertaken the following steps. Anong ginawa? Assessee. Sino yung mga assessee dito? Redington, India Limited. Incorporation of Redington International Mauritius Limited. So itong Mauritius, this is already also another tax haven country. No? So incorporation of Redington International Mauritius Limited, or RM, in 2008 with initial investment of US dollars 25,000 fully held by the assessee. Incorporation of Redington International Holdings Limited in Cayman Island. No? So, by Mauritius na siya. May Cayman Islands pa. And the entire share capital of RC was held by RM. And on November 13, 2008, RG gives its shareholding to RC. Binigay lang niya. No? So, ito yung under question na transaction. No? Kasi si Redington, binigay lang niya yung kanyang shareholdings to Redington Cayman. No? Imagine, napakalaki na shares tapos pamigay mo lang. The SEC would state that the transaction complies the local law requirements of gift. No? So, nag-avail sila ng exemptions na sinabi nila na gift daw yun. So, of gift in UAE, and such a transaction was necessitated to facilitate IVC's investment in RC. The explanation of the assessor for incorporating RC in Cayman Island is that the private equity fund was interested in investing in the Middle East and Africa's operations of the assessee, and to facilitate the same, it established IVC GOFRG in Cayman Islands. The explanation of this assessee for incorporating RM in Mauritius is because IVC imposed a precondition for investing in RC that it would be acquired to be listed within 3 years, failing which IVC had an option to exit by selling its shares to the Redington Group. No? A price determined having regard to the fair market value of the shares. But in any event, it would guarantee an internal rate of return of at least 7% for IVC. Further, it is submitted that the Redington Group was saddled with a liability to reacquire the shares of RC from IVC if the shares of RC are not listed on a stock exchange within 3 years. So, within themselves, may mga transactions na nangyari, no? Pero ano talaga ang nagiging issue dito at saka ano yung nagiging verdict or decision ng court. No? So, sinabi ko na sa inyo yung issues kanina. Ilan yung issues? 3. No? Ano yung resolution ng court? Ano yung sabi ng court dito? Ano yung decision niya? Ang decision po dito ng court is in favor of the tax authority. No? Okay. So, anong sabi dito ng court? In the light of the above decision, we hold that the tribunal committed an error in deleting the addition made against corporate and bank guarantee and restore the order passed by the DRP, yung dispute resolution panel. So, anong decision ng court? Binalik yung disallow na bank guarantee, no? The revenue had preferred appeal before the tribunal challenging the order passed by the DRP regarding the finding that the PE fund was relatively risk-free investment without taking note of the discussion made by TPO in his order. No? Okay. So, nasinit aside niya yung finding ng court, no, ng lower court. Okay. Okay. So another, we find from the order of the TPO that the grounds canvassed to the SSA before the DRP were the same as it was canvassed before the TPO. The TPO held the cap method. So ano yung the best method daw na gagamitin dito sa case na to is the comparable uncontrolled price method. Is the most appropriate method since a similar transaction had been taken place within 1 week. So, anong klase ito? Internal comparable. No? On November 13, 2008, namely, shares of RG held by the assessor were transferred to RC. No? Within 1 week lang yung dinonate na shares of stocks, tinransfer ulit. No? Unrelated party. The PE Invest Corporation acquired 27% stake in RC. Therefore, the TPO came to the conclusion that this uncontrolled transaction is ideal in determining the arm's length of the shares of RG. No? So, kaya nga sabi ko sa inyo, what is being used here is the internal comparable. No? That has been transferred to RC. More important with regard to the circumstances under which the said transaction was done. No? The TPO noted that the assessee has sought permission from the RBI through one of its agency bank, the ABN AMRO, wherein it was mentioned that the assessee, that the PE, is interested in acquiring the stake in RG Dubai. So further, the assessee passed a resolution in their board meeting on July 25, 2008 about investment to be made by the PE. The assessee admitted that it was their objective to list the share in an appropriate stock exchange overseas. So the TPO, on analyzing these facts, held that the assessee knew that the PE investor is going to acquire a stake. Kaya nga transfer nila at ang bilis lang, no? So doon sila natalo. Kaya yung findings ng mga assessment na dinisallow nung appellate court pagdating po sa higher court, the Supreme Court, binalik lahat, no? So yung mga inalis niyang assessment, binalik. Okay. Okay. So, mahaba po yung desisyon nila, pero ano ko na lang sa inyo, no? At ano po yung nasabi dito about the lahat ng findings ng appellate court, binalik nung ah, binalik na ng higher court. No? Kaya panalo dito yung tax authority. Ito yung concept ng bank guarantees and corporate guarantees. Explain na yan sa mga transfer pricing cases. Okay. So, the case that we discussed tonight is about the Principal Commissioner of Income Tax versus the Redington India Limited. So, in this case, talo po dito yung Redington India Limited. No? It was proven na tama yung transfer pricing officer. No? So, anong decision dito ng court? So, binalik lahat ng mga dinis-allow na ma-assessment. No? So, naging valid ulit yung assessment. And no cost, wala pong cost dito na granted. Panalo lang yung tax authority or yung Commissioner of Income Tax ng India. No? So, with that, I would like to say thank you po and good evening.